it's daunting because you're on such a big stage, and I think all of us count in our lives on there not being anybody looking if you make some big mistake. At least we all hope that we'll have some number of mistakes we make in our professional lives that will not be immediately broadcast on the internet with a transcript available and with lots of people in attendance in a sort of big public setting. So that prospect hanging out there that you don't want to mess up in front of the world means you work really, really hard to be ready. And before arguing the case today, I had done 4 full dress rehearsals in the last 2 weeks, where I put on a suit and went into a courtroom and had people acting as the judges who had read all the briefs pepper me with questions for 35 minutes to make sure that we could try and figure out every possible thing I might be asked and how I would react to it. One was the Tenard versus Dretke, which was a death penalty case out of Houston involving a mentally disabled young man who was convicted of murdering someone during a robbery. And the legal question was whether his mitigating evidence could be given meaningful consideration by the jury, given that they were limited to some very narrow inquiries. They were not asked, for example, should this guy get the death penalty? They were asked, was the murder committed deliberately, and is he likely to be dangerous in the future? And if the answers to those 2 questions were yes, they didn't have a third option of saying, but we'd still like to give him a life sentence, seeing as how he's mentally disabled. So the whole question for the court was whether the absence from the Texas sentencing scheme of any opportunity for the jury to give effect to the guy's mitigating circumstances made it unconstitutional to execute his death sentence. And we ultimately prevailed on that case, and he was resentenced to life. And then the second case I argued was a very similar question about the jury sentencing instructions in a case involving different kinds of mitigation. Instead of being mental illness, in those 2 cases it was basically a troubled background. My clients had both been raised in environments where they were really mistreated by their parents, and it had left them with some real adjustment problems living in the world. And both of them were subsequently convicted of murders, and juries were told about their background, but then were given these instructions that didn't really tell them what to do if they thought that justified not giving him the death penalty. So, and both of those cases were reversed, and one of those clients has been resentenced to life, and the other was actually resentenced to death. There are a lot of influences. I think there are cultural differences between Texas and the rest of the country. I think that Texas has a self-consciously muscular and punitive attitude toward criminal punishment. I think there's also there are real problems with the quality of defense representation in Texas. I think that it is not uniformly high quality. It's important to actually, as they say, do the math. When I got to Texas in 1989, there were about 30 to 35 new death sentences a year statewide. And that number now is down to 12, 13 a year. And that's a reflection of a nationwide trend. It's true in Dallas, it's true in Houston, it's true in El Paso, it's true in Austin, that after life without parole became available, the number of death sentences dropped off in all those jurisdictions. Because I think that speaks to the fact that many capital juries are concerned about public safety. The reason people don't want to give prisoners a life sentence is because they're just afraid that if you turn them over to state authorities, they will not be sufficiently careful, and they'll turn them loose, they'll parole them, and so it's weird. It's like, because we can't trust the government to take care of us, so we're going to have to kill this guy ourselves. One of the main cases that was a subtext of what we're talking about today was a decision from 1994 where the Supreme Court said that the fact that you may have been wrongly convicted, by which I mean you are factually innocent, and you can show that, the Supreme Court said in this 1994 case that that's not a basis for giving you what's called federal habeas relief, having a federal habeas court release you from custody. The problem was that in 1994, when the Supreme Court first sort of dealt with this issue, was before the DNA revolution. And it's so funny to read this opinion now because it reads like a decision from the 19th century to the extent of how much our knowledge has changed since 1994 about wrongful convictions. I mean, that's been a revolution. And I think today, if the court had to deal with the same case, it would have to acknowledge that wrongful conviction is a bigger problem than it allowed in 1994. And you saw Texas go into the Supreme Court and say, we believe that if a person had a fair trial, it's okay to execute them even if they can show they're innocent. And that's that Texas toughness. We go into a federal court and say, our client's actually innocent and we can prove it, that federal court is going to say there is no Supreme Court decision that helps you. And we could end up back here with this argument armed with exculpatory evidence saying, we've got you, now you have to announce, you have to overrule Herrera. You've got to tell us that that decision was insufficiently protective of the public interest in not executing innocent people. And you can do that because we know so much more now about the reliability and accuracy of the criminal justice system than we knew in 1994. And precisely what we know is that DNA is the lens through which you see all these flaws.